case briefs, and so much more. LSData's got what you're looking for.
In 1987, the Florida District Court of Appeal heard K.V. Swartz, a case centered on an exception in Florida law concerning adopted children and inheritance. This exception allows an adopted child to inherit from their biological family, specifically through a deceased parent, even if they are adopted by the spouse of their surviving parent. The case began when Paul K., nephew of Jacob Kanevsky, challenged a court decision permitting Perry Swartz, the adopted son of Jacob's deceased niece, to inherit from Jacob's estate. Jacob had no children and only one deceased brother, who had two children, Paul and Zena. Zena had adopted Perry, who was later adopted again by her husband's second wife. The Florida legislature had created an exception, allowing adopted children to inherit from their prior family, as well as their adoptive family. The trial court ruled that Perry was entitled to inherit from his deceased mother's family, including Jacob Kanevsky, and the Florida District Court of Appeal affirmed this decision. Ultimately, the court held that, under Florida statute's adoption exception, Perry Swartz was entitled to inherit from his deceased mother's family, including Jacob Kanevsky. The court concluded that interpreting the exception as applying only to blood descendants would create a conflict between the Probate Code and Adoption Act.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.